Thank you.
Thank you very much. I think we'll do as short a break as possible and we go to Petron.
Mr. Chair, given that we only have 35 minutes left and I believe 27 minutes of presentation, and we're still trying to have a commissioner discussion about process, and we need to get all of our stuff out of here by 5, could I propose that we skip the break and?
We only have 12 minutes
So-
left.
We only have
Oh,
12
we do?
minutes
Okay.
12
left.
minutes left,
Okay.
and the 5 o'clock deadline apparently is not as firm as we had thought. So if we need to go over a little.
Okay, then I withdraw my squawk.
Thank
Thank
you.
you.
Thank you, Howard.
We're gonna get overruled.
I was gonna say, everybody cross your legs. Let's do this.
Until Howard.
Or just take turns.
You gotta tap out. Get the bathroom.
Yeah.
I'm sorry? Shall we? Ms. Bryan?
Their Petron development has 12 minutes near the last part to present.
Best guy in the room.
Perhaps not the least.
Start.
Not the least.
Oh, yeah.
I think this is good.
Okay. So we begin?
Begin.
I was going to start off with good morning, then I went to good afternoon. I think we're close to good evening. Commissioners, staff, parties, and members of the public, thank you for the opportunity to provide comments in regard to this very important and complex rulemaking. My name is Jimmy Walker, and I work for Petron Development Company. We are a second-generation oil and gas company operating mostly in Yuma County with a few operations in Washington County. Here at the start of my presentation, I would like to make two things clear. One, Petron understands and fully supports the basis and purpose of this rulemaking. And two, Petron supports the concerns expressed by the industry and fully supports the recommendations provided in the various industry presentations. First, let me provide you some brief economic pictures of the oil and gas industry in Yuma County. There are just under 4,000 wells in the county, all of which are natural gas wells. These are older vertical wells that produce low gas volumes under low pressure and are located in very rural farming country. In 2016, the average production per well was 16 MCF a day. The average gas sales price has been running about $1.75 per MCF. These conditions result in a gross income of about $28 per day per well. The average daily water production of all wells in Yuma County was just over 1 barrel a day. It's difficult to state the true average of a particular well's daily water production in that there are a number of different configurations in place to move varying amounts of water. Our velocity strings produce 2 to 3 barrels of water per day per well. Our pumping unit configurations produce about 5 barrels of water per day per well. And of course, where we have no lift mechanism in place, water production is zero. I try to keep as close a track as I can on activity in Yuma and Washington counties. It is worth noting that in Yuma County, it appears no wells have been drilled in the past 3 years and only a handful in the past 5 years. So it's accurate to state the current operating environment causes the economics of production in Yuma County to be marginal. Hopefully, this helps give you some insight as to the economic challenges we face in our day-to-day operations. Given the low risk posed by our operations of these wells in this remote rural setting, Petron is concerned that the new requirements of flow lines in the proposed rules will result in little benefit, yet impose significant cost. Now for some of the more specific concerns regarding the rulemaking. As to the request for additional insurance requirements, the various proposed insurance requirements, $5 million liability and $5 million environmental, are examples of proposed red lines and additions to the rules that are outside the scope of this rulemaking. In addition, such requirements would render many operations non-economical. Coverage of a standard general liability insurance policy carries $1 million per occurrence maximum and a $2 million per year maximum. In addition, these policies typically include an environmental clause known as sudden and accidental or time element. It would cost an additional $10,000 annually for Petron to increase its coverage to include the $5 million limit. In addition to the increased costs I've just outlined, local governments are also asking for an additional coverages of another far less common type of coverage known as pollution legal liability policy or a gradual pollution policy. For Petron, these types of policies would cost an additional $40,000 per year for $1 million in coverage and $57,000 a year for a $5 million policy. These costs are all in addition to the primary general liability insurance that we do carry. These rates are quoted for an operator the size of Petron. Petron currently operates 114 wells in Yuma and Washington County. As operations get larger, these costs become greater. Since these rates are based on a generally well-by-well basis, much larger operators would end up seeing astronomical increases in their insurance costs. costs associated with these types of coverage is prohibitive, these types of policies may not be available to many operators. Petron's next item of concern is in regard to the financial assurance requirements proposed in Rule 711 for the newly defined produced water transfer systems. It's important to note that small operators such as Petron are unable to obtain a bond at reasonable rates. We have to put up cash as collateral for the entire amount of the bond. Currently, Petron operates one water transfer system consisting of 6 wells, producing approximately 5 barrels a day for a total of 30 barrels, 5 barrels a day per well for a total of 30 barrels for the entire system. In the past, and as recently as November 16th, the Commission has worked with and encouraged industry to design, install, and operate these types of underground systems. I'd like to refer to the Governor's Task Force on Oil and Gas report from work group on recommendation number 37, reduce truck traffic from oil and gas activities. The Governor has expressed a desire to further develop these types of systems. The purpose of these systems is to continue to transport a product, water and oil, while reducing truck traffic, noise, dust, tanks, pits. The costs are not inconsequential when it comes to the installation and operations of these lines. To add to these costs in the form of financial assurance seems counterproductive and, quite frankly, in conflict with the findings of the Governor's Task Force to promote the use of these pipelines. As an example of these unintended consequences, should this rule be adopted as currently proposed, Petron at the one location where we have such a facility will consider removing the lines and going back to the pit evaporation systems we originally had in place in order to avoid the burdensome financial assurance requirement. Petron urges the Commission to support provisions to Rule 711 that would allow for the following. Operators of small produced water systems transporting less than 1,000 barrels per day are exempt from the Rule 711 unless the Director determines a pattern of violations demonstrated by the operator of the system. An additional and final concern that Petron offers testimony is in regard to domestic taps, Rule 1101B. Where there are domestic taps attached to Petron wells, 2 purposes are served. One is to heat the home of a mineral owner, and the other is to run the irrigation equipment of the mineral owner. As I explained in my pre-hearing statement, domestic taps come being by implementation of several different types of rights and agreements, 2 of which are directly applicable to Petron and the mineral owners and interests it represents. 1 is right by lease, 2 is right by ownership. In both instances, Petron provides a ball valve that allows the owners to access their gas at the wellhead. Custody of that gas transfers to the owner at that ball valve, aka the domestic tap. Under the terms of the lease or the terms of the joint operating agreement, Petron has no right or authority to access the gas tap downstream of this custody transfer point. These examples of custody transfer points of gas at a domestic tap are analogous to more conventional configurations where the gas is marketed via connection to a gas gathering or transmission line. For these configurations, when the gas moves to the gathering or transmission line, aka third party, custody transfer occurs at that specific point of connection to the third party's gathering and transmission system. No right to control or dictate construction, supervision, maintenance, or operating terms of that line than it would have for the domestic tap examples. Furthermore, Petron does not have the equipment, experience, nor liability insurance to work these specific types of lines. While Petron has contractual obligations to provide access to an owner's gas, Petron shares no ownership or rights to these lines or gas. Petron can provide, and has, the name and location of the well being tapped and the contact information of the party arranging for the taking of the gas from the tap. We cannot provide a service location, destination address of the gas. We would not know how to provide an address for an irrigation system, nor do we monitor the activities of these lines. I am a bit perplexed as to why the counties would not have already regulated these domestic taps. If I wanted to install a gas stove in my home, I would be required to get a permit from my county, have a licensed plumber install the line, and have it inspected for proper installation and safe operations. As long as the counties are regulating the installation of the gas line for the stove, it seems appropriate and logical for the counties to regulate the gas line that also serves a similar purpose. The statement of basis and purpose states that, quote, "The commission expects that an operator can satisfy the regulations by contract provisions that require the surface owner to ensure installation is performed in compliance with the rule. The safety and integrity of the domestic taps are not regulated by the commission." Here, the commission has recognized it does not have the authority to regulate domestic taps, but looks to the operator to somehow backfill that lack of authority by modifying existing private contracts or by the creation of new private contracts. This seems inappropriate, and it's not a matter that I'm willing to support. To summarize Petron's concerns expressed today, asking that the commissioners not consider additional pollution insurance requirements, and these proposals are outside the scope of the rulemaking, cost prohibitive, and may not be available to all operators. 2, the newly defined transfer systems that reduce truck traffic, noise, dust, tanks, and pits should not have to carry additional burdens of financial assurance. This is counterproductive to the encouragement of the use of these systems. And 3, the regulation of domestic lines are more appropriately are the domain of the counties and local municipalities, just as other interior construction programs related to the same are. In closing, I'd like to express my immense appreciation to the COGCC staff, and I do mean that, the various trade associations, and to my brothers and sisters in the industry, all who have worked long, late hours in an attempt to craft workable rules that make us all safer. Thank you.
You have a question,
I do have a question.
Commissioner Overture? Okay.
I apologize if you said this and I missed it, but how many, you said that your company does have one of these produced water transfer systems?
As now defined, yes, ma'am.
And how many barrels of water per day does your system?
And I apologize, each well produces about 5 barrels a day. There are 6 on there, so about 30 barrels a day.
Okay. So, but you still oppose because the rule 711 was changed to create an exemption for 80 or less. Is that
yes.
okay?
I appreciate that. There are a number of things, and yet in the interpretation of what flow lines are, water gathering, water collection facilities, there's still a lot to go with that. But with this, out in my county, and I've expressed the economics and the type of production out in our county, there are some larger systems that we've all participated in putting in. In other words, my interest owners have interest in other systems that are larger than mine. And I originally said 500 barrels, but I went up to 1,000 barrels. This is in my pre-hearing statement. I'd asked for 500 barrels in my rule, in that number instead of 80. But I also asked that there be no financial burden. Again, as smaller operators, I have to put up the cash. In my situation, not only do I have to put up the cash, but I'm also paying to a third party as that water leaves my system, goes into theirs for their disposal. So my costs keep increasing on these systems. I've got to get rid of it. But I'm asking for the 1,000 barrels because now I'm seeing that the other systems that out of my county from other operators, they're larger than me. I'm getting a better handle on how much production they have. They were built on the same premise and idea that my system was built.
Okay. And then how many, it sounds like you have a great deal of experience with domestic taps. How many do you have? Or how many exist on your system?
I have, I'm not going to lie to you, I'm not under oath.
Well, don't lie to us either way.
We can do something.
I opened my mouth, I'm sorry. We have 4 that heat houses and 2 that run irrigation systems. In the 2 in the irrigation systems, they actually participated in the well. So they're a working royalty interest owner in the well. And just like any other person, they take their gas in kind. In this case, they take it to run their irrigation system.
Right. So, and do you know when the last domestic tap was installed on your system? And if you don't, that's okay.
I want to say, no, I can't. I want to say it's been within the last 5 years, but I can't remember for sure.
Okay. So the specific requirements about the capabilities and operation of the domestic tap only apply prospectively. So only apply to new domestic taps going forward.
I understand that, but
And I'm trying to just understand how much of a burden that places on you if you see domestic taps as something that you're going to be doing more of going forward, or I'm just trying to understand the scope of the impact.
It's quite possible that a homeowner would say, I want to hook up to the well. Or let's just take that case. That would be true. I don't want the liability. I don't want the liability. I don't want to be the supervisor, regulator, or anything of that line. That is contractual. That's away from me. I have no right, authority, or anything to do with that. And I can't accept that would be given to me.
And so then you wouldn't be required to install a domestic tap in that instance, right?
No, so what we do is we provide them a ball valve.
Okay.
And we don't, what we did with the NTO process is we sent them a letter outlining, what the concerns of the commission was, what they were looking for, and recommended that they do some things. That's about as far as I dare go, and I had an attorney help me craft that letter, so I'm not stepping into areas and leaving myself open to liabilities.
Okay, those are all my questions.
So a bit of clarification, and this may be stat with some help from Mr. Ellsworth, perhaps, when I look at what the definition says with respect to a domestic tap, it says connected to an operator's flow line. And then the operator has to register the tap based on a report that includes the latitude and longitude of the flow line or wellhead connection, which to me, the way I would interpret that in the example that Mr. Walker provided is he files a Form 44 and says, ball valve is located here. That's the tap. That's the end of his liability. He doesn't have anything else beyond there. It doesn't matter because he's satisfied that per the form requirement. He's satisfied that by saying, here's the tap, here's the location. But help me out.
Yeah, they're a little bit more. We're asking for the address of where that's going to. So the street address. That tells us where it's going to. So from the registration process, we're asking for those two basic items. And then we do have a few other items listed in 1101B as far as markers. So a marker where that tap is, and then the marker at the house where that is coming into the house. We are asking for that to be odorized, and we're asking that to be installed by a licensed plumber. Some of this language and perspective we got from La Plata County, who does do exactly what Mr. Walker says. They inspect those, I believe, on an annual basis or periodic basis. And so they've taken on that role that he is presenting. So we took several of those pieces of language from them, and also the state of Arkansas. We reviewed their domestic taps.
So the question then is that, as far as when you have that more or less a custody transfer point, is that ball valve? We can get into if it's supplying a sprinkler system, street address may not be appropriate, but there's some other place you can say, well, the line terminates at this latitude and longitude, which presumably you can get that.
Sure.
But sort of struggle with where does the operator in this case, where he says, I've surrendered, my custody transfer point is that ball valve. How do you take care of the odor issues? And this is we're talking about existing taps. And then going forward, any new taps, what are we going to do?
And if I just may,
You bet.
Certainly for operators like Mr. Walker, it would be up to him to determine where that wellhead location is, or where a homeowner taps into it at a flow line. So wherever he says that is, he can certainly provide that information to the commission. The rule, as you've articulated it, clearly sets forth where those points are, where an operator needs to disclose where someone taps into it. And just one other item, Mr. Walker noted that, or stated that he felt that the commission does not have the authority to regulate domestic taps. That's not correct. Potentially, he may have been alluding to a statement that we have in our statement of basis and purpose, the draft statement of basis and purpose on page 7, where the commission just recognizes that PHMSA also has safety regulations that apply to domestic taps. Testing requirements, pressure testing requirements, but that does not, our proposed rules are not impeding upon the PHMSA pressure testing requirements for domestic taps in any way.
Okay.
Mr. Chair,
Yes, Commissioner Boygan.
I don't think that's what Mr. Walker was saying. I don't want to put words in his mouth. Certainly, I can't do that any better than he can. But I think what he's saying is that his legal right to do anything with respect to a tap ends at the connection to his well. Beyond that point, it's not his property. It's not his gas anymore. And the language of this proposed rule says that the operator shall ensure, as far as taps going forward are concerned, that these various things happen, including that a licensed plumber installs regulators, both where the flow line connection is and at the connection to the dwelling or structure, all necessary piping to accommodate odorization, metering equipment, blah, blah, blah. And I think he's saying he doesn't have the legal right to do that, to require it, and doesn't want the liability. And so, and I have some sympathy with both of those issues, and hearing Mr. Ellsworth say that you used La Plata County as a guide doesn't surprise me, and it tracks with Mr. Walker's comment about it's sort of a county function, and you could solve this issue, it seems to me, by saying in a couple of different ways. Either that you limit the operator's responsibility to the well connection, the tap itself, and then structure the rule to require the owner of the tap or owner of the gas to comply with these requirements as a condition to being able to utilize the tap. I think then you're still regulating, the commission's still regulating it. You're just putting the regulation on the party that actually has the ownership of it, the legal right to do that, and a liability. Or you could say, I suppose, this one's a little more problematic because it gets into the issue of interfering with private contracts, but you could say that the operator can't effect the tap, can't implement it unless the owner of the tap rights provides sufficient confirmation that these various items will be achieved, will be implemented. So I think it's a valid question about who's the responsible party here.
Certainly, I think Director Lepore wishes to speak to this as well.
Director Lepore.
Thank you both. So Commissioner Boygan, your option B that we say to the owner of the tap, you must do the following things. I think it's the judgment of our Assistant Attorney Generals that the commission doesn't have authority to regulate those private parties that are not oil and gas operators. So, yes. So they can correct me if I'm wrong, but I think that we have never believed we have the right to regulate a homeowner who is taking gas from a domestic tap. So,
With all respect, I'd like to hear that discussion.
okay, so hold that thought. With that in mind, what was in our minds in drafting this was your option C, which is that by contract, the operator can say, I will give you a domestic tap. However, part of the agreement must be that you will hire a licensed plumber to install it, that you will ensure that the bedding material is proper, that the odorant is supplied, etc. I'm always interested in industry's arguments about interference with private contract, which I think is generally overstated, that we regulate their conduct all the time that implicates contracts. And here, we're not, all they have to do is put that in the contract. Whether the owner complies is a different question. And again, in my opinion, not within our jurisdiction.
We're getting into deliberations here, but this provision applies to pre-existing taps.
Does not.
No.
For domestic, oh, I'm sorry, you're right, you're right, okay. Future taps under potentially pre-existing agreements, but future taps.
See, I agree with that. There could be a lease that says I can have a domestic tap that I have not asked for, and now I come and ask for it, and that lease doesn't say anything about any of this.
I agree that as to future contracts, future leases, everyone's on notice, this is what the rules require, no issue.
Right.
Would you like to speak? I think
I would love to speak, Chairman. The lease isn't it is a private contract. I already have a contract. I have a contract with the lease that says that he has the right to take gas at his own risk and cost. And so I have the contract. And he says, all right, Walker, I'm going to hook up to you. I said, wait a minute. We need to enter into another contract. I hope he doesn't have too big a dog because he'll be chasing me off his land really quick. They won't do another contract. He'll want to hook up to his gas as his lease agreement contract says that he can. And again, where my responsibility, my legal liability, my exposure, where that all ends is at that gas tap. Petron's case, for clarification, there may be gas taps on flow lines. I don't know. All our gas taps are at the wellhead. But I've had this discussion before. I'm very, what's the word? Committed to this thought process.
Go ahead, Director.
Thank you, Mr. Chairman. So, Mr. Walker, under that lease, and it's at the wellhead, you install a ball valve and say, here's the ball valve, come and get it.
Yes, sir.
Okay. So a workaround that I can think of as I sit here is that this apply both to domestic taps installed after the effective date under leases entered into after the effective date, I guess. I mean, you're saying that, at least I think you're saying that, again, you have leases that are extant today that the lessor has not taken advantage of that domestic tap clause. And tomorrow, if he or she comes forward and says, okay, hook me up, you don't want to do this new contract.
They'll tell me I already have a contract.
Right.
It says right here, I take gas. When I signed that lease and you said you wanted to drill for them minerals.
And can I just ask, because I don't have anything better to do for the rest of my life, if La Plata County or any other county decided to regulate this, they would say to the homeowner, we want you to hire a licensed plumber to do this. You're fine with that.
Absolutely.
That's
I think
outside
where
of
it
your
should be.
purview, outside of, okay.
And I get what's trying to be captured here.
Right.
Honest to God, I do. And I agree with it. It's just not on me. And I do think the counties should be looking at that. That seems appropriate.
Mr. Chair, may I ask just one final question
Certainly, Commissioner Overturf.
of staff? And I guess,
But that doesn't necessarily mean that that's the final
oh,
question.
it's my final question. Rather than making state policy based on a single lease that may exist today, this operator could always come forward and ask for a variance with regard to a lease that exists today. Is that not an option?
Yes, I'm just struggling with the practicality of what's really going on. The lessor comes forward tomorrow and says, hook me up. And so Mr. Walker then has to come to us and say, this is a pre-existing lease. I'm going to hook him up and I'm not going to make him do all this stuff.
I mean, I'm just, rather than, it seems strange to me that we're having a conversation about rules of statewide applicability based on a single lease. And I
don't interpret it to be a single lease. I think
Okay.
he is not describing a one-off situation.
No.
Okay, then I may be misunderstanding the situation.
Okay, this is, okay, was it a 56? The attorneys in the room should know this better than me, but it's not all leases have this clause. Not all our leases have this clause, but there are a substantial amount of older leases that do have this clause.
Okay,
And you guys do try to make me do anything, you're putting me in a very hard rock and a very hard place. So I ask you, please.
Mr. Chair, if
Commissioner Boygan,
real quick,
go ahead.
I think one beneficial outcome of this discussion is it's clarifying for the local governments that as far as the commission's concerned, there's not a problem if the local governments want to regulate the owner side of that tap. So maybe they're getting that message loud and clear, and that will ultimately address the issue to their satisfaction because they can go regulate it.
So agreed and good point and well taken. What I'm trying to recall, and I'm looking for La Plata County out there, I don't see them. They did ask us to put this language in our rules, and I cannot recall now their rationale, their logic for why they don't want to do this, but it was an ask specifically of La Plata County that we do essentially what we've done here.
So we have a wealth of attorneys in this room to help me with this question. When I read this, and I understand that it's a lease that says this person can come and get the gas, and he comes and he says, well, that's great. You can have that gas, but the rule says this is what you have to do. The rule, why is the rule subject to the lease? To me, they're two separate items. And it says, yeah, you've got a lease. You can come and get the gas, but the rules have changed as far as what you have to install. And you're going to have to go get a plumber, install it, put the odorant in. That's what the rule says. And I can't give you the gas until you do that. That's another way to go approach that. Then then that person has to go and put that in there. Or you can say, or we can sign up. We can go ahead and sign a new contract. And as the director said, we'll sign a new contract that says you will do that, but I'm absolved of any liability associated with it. So whether you choose to do that and put the regulator in and the odorant in, that's your decision and your choice. All you're going to have to do is sign this contract that says that you will, and then that's your liability and your responsibility. So you have, to me, there's sort of two different ways you can go here, and I'm looking for, and again, we're sort of deliberating around this, but I think it is something worth talking to. Go ahead.
You're putting me in the place of being your regulator, being your field inspector. I'm not willing to do that. You don't pay me enough. Not only that, you're putting a burden on me to do all kinds of things that I have no legal right to do. My fulfillment of that contract is there's your ball valve. If you folks would want more of those lines looked at, then you need to go to them. If your legal advice tells you you can't go to them, you can't go to them through me, but you can through the counties. That's the appropriate regulatory body on these lines.
If I might.
Yes,
Mr.
Commissioner
Chair,
Warren.
I think to get to where you're suggesting we go, because I agree with your point, slight tweak of this rule to make it clear that the operator can't install the tap, even under a pre-existing lease, unless the owner of the tap rights provides appropriate assurances on all these points. That way, it's not the concern that Mr. Walker has is that he's taken on this liability, or that you're putting him in this position of having to potentially get into a fight over what his contract. If we just pass a rule that says he can't do it unless, and it is specifically the tap owner's responsibility to provide all these things, then I think he's out of the picture, and then it's between us and the owner of the tap rights.
Yeah, I'm sympathetic to that we put him in that position of having to be the regulator. It's a fine line because notion says, all the house here, you're going to come and hook up to me. By the way, you need to go look at the state rules for what you have to do to hook up. And you have to understand
Fine.
what those are.
Yes, as long as it's that party that's doing that and not him.
Right. He doesn't, all I'm going to say is that the rules have changed. You're hooking up to this. You have to go read the rules. And it's where do you go to that stage? It says, all right, you sign this piece of paper, said you read the rules. And you understand what you're supposed to do. And then I still want my gas. I don't, we won't solve this today, but
I understand that.
go ahead.
It's still putting me in a severe cross, and I'm still acting as the regulator because, okay, he says, okay, I'll do all those things. Great. Need that tap. All right. Gonna do it all. I put on the tap. He hooks up. He doesn't do any of it. Or, like with the stink and all that good stuff, he takes it out. Or he doesn't keep his stink up to par, keep it filled.
To me, it's not your liability because he said he would do it. He went and did it. If he chooses not to do it and his house blows up, that's not your problem. He has taken that responsibility because he was informed by the rules that this is what he's supposed to do. He's just chose not to do it because your contract says all I give you is a valve. At that point, the gas custody is transferred.
I'll even include in my notice to the commission that I, in fact, provided him with the rules.
I think that would be appropriate.
Thank you for your understanding.
I mean, that's going to be up to the rest of the commissioners and I think the staff and the director to say if that's acceptable because I'm not the attorney. I don't know whether or not that's the way that would be interpreted.
I don't want to prolong this.
Yeah, I don't think we need to keep going on this one. So briefly, just a comment to staff. There was a request on the Rule 711, a bit of a change there. As I said, exempt from the additional financial insurance unless we establish a pattern of violation, which gets to the issue about responsible operators versus irresponsible operators. I'm looking for a comment from staff. Would that be something that we might contemplate as part of that rule? Or do we see issues with that?
Well, I'm going to first comment that what we've done is we've added a 80 barrel per day of water clause in as a reduced bonding requirement, much like a small operator clause for the gas. We've included a water clause. So that's kind of where we are now.
Although we've heard that there are larger systems out there by smaller operators that potentially up to 500 barrels a day or 1,000 barrels a day, and it's sort of still a small operator with admittedly skinny financials. Go ahead.
Well, we're asking for a $5,000 bond.
But that's 80 barrels a day.
Right. And I took a look at, small, what I could try to determine is small volume wells in Yuma County and some of the other locations. And that's kind of how I got up to the 80 barrels a day. I could probably discuss with Mr. Walker sort of how he gets to the 1,000 or 1,000 barrels a day. But that's kind of in parallel with the 5.
Okay. We're not going to solve it. I think Director Laporte has a comment.
I actually would like to ask Mr. Walker a question. When you were describing these larger systems, it sounded to me like it was some kind of consortium of smaller operators. And so what I'm really wondering, is it in fact a single operator operating that system, or is it a group of operators?
Generally, it is an operator that owns the system. It could be a consortium. Could be one person that owns that system. Could be the operator that owns that system. That operator operates maybe a few hundred wells and set up this disposal system to try to reduce the costs to the interest owners. in those wells. So the interest in the water system may be the same as in all the wells, or it may be a separate interest, a different breakout of interest depending on how it came about, what systems come in, what wells come in at later dates. My concern is again, as I said, whenever you talk about financial assurance for guys like me, I'm putting up cash.
And I guess my follow-up question is, it sounds like there's a number of interest owners who would help you put up the cash.
If the economics allowed it, and what I'm trying to say is, I don't believe they do. In my case, it doesn't. And it feels like we're getting. I was a little surprised when the rules went there, and it feels a little bit when we thought we were being good guys putting in these systems. It feels a little bit like we're getting punished. Just tell you how we feel. It ain't. I know that's not what you're trying to do. That's what it feels like, and there's discouragement now in putting in these types of systems.
So I appreciate your comment. I appreciate that, we have otherwise said to operators, go forth and do this. It's a good thing. It's a better alternative. I'm also aware very much of the increasing number of abandoned flow lines and wells and everything else that we're facing. We're having this conversation about increasing financial assurance on lots of things. And this is going to be the argument every single time. So I think, maybe 80 barrels is not the ideal number, but I think, well, financial assurance is not going to go away as an issue.
Any other questions? All right.
They told me you were going to be brutal.
We're not finished yet with the financial assurance. So. Thank you very much.
Thank you. Thank you all very, very much.
Your patience of waiting all day long.
This is difficult work. Thank you, guys.
All right. So we've had a discussion, and I believe Commissioner Overturf sort of volunteered to propose what we do next. Is that a fair statement, or am I just putting you on the spot?
I'm happy to tell everybody what to do, but that doesn't mean you have to do it. I've been thinking a lot about how this day has progressed and what the next steps are and how we can resolve this matter in an orderly fashion. And so my proposal would be to have 2 filing deadlines and then a subsequent deliberation meeting. I am aware that we kind of pushed the parties off with their closing statements. And I am also aware that staff has identified a number of areas in the rules where they wanted to spend some more time talking with other parties, or perhaps providing additional clarity or detail to the rules. So my proposal would be that the first round of comments would be closing statements on the hearing from the parties, and concurrently filed a new red line set of rules from staff that would include the things that have been discussed today, and then perhaps a second round of comments where parties would have an opportunity to respond only to the rules that were being proposed by staff. Then at a hearing, perhaps in February, the commissioners could jump straight into deliberations. That, I think, satisfies due process for everyone, gives everyone an opportunity to respond to everything without requiring significant additional hearing time, because it does seem like deliberating on these issues is going to take a significant amount of time, and I want to make sure we have ample opportunity to engage in discussion and back and forth. So that's my proposal.
Commissioner Boygan.
At the risk of prolonging this whole process, which I don't really want to do, and I do like the proposal, I would just offer that I see some value in the opportunity for parties to present verbally or to present to us in addition to, so that we can have a final interchange with them and they can further elaborate on whatever points they're making. And if we decide to make that part of this process, I would suggest that we could require consolidation among the different groups, industry, local governments, maybe other surface owners or something, give them each some allotted time. But if the rest of the commissioners don't see any additional value in that, I'm happy to support Commissioner Overturf's proposal.
Think about that. Commissioner Hawkins.
I also find some benefit in having a verbal closing statement, just kind of bringing a little more clarity to what some of those key points are and how we might resolve differences. I mean, I think we're going to get written closing, written comments from people and a red line section, and then there's still going to be a lot of conflict. And so it's beneficial to me to hear from the parties as they're in their closing statements what their reaction to some of those changes are, and maybe be beneficial to me to help figure out a way to resolve some of those conflicts.
And one of the options, and I'm not sure if this fits in within the framework of what's being proposed, there are a number of issues as we work through today where there are a number of items that there's a variety of positions on this. Thinking about, could we at least quantify that and ask the staff to go back and work with the stakeholders that these are the things, the specific items that we see that there's significant variation in where the wording of these specific rules ought to be. As an example, mapping. I think Director Lepore said it as well as anyone. We're all over the map.
Waka, waka, waka.
To be with that. And some of the other things around maybe some of the other bits and pieces like Rule 201 that can be done fairly quickly. Selfishly, I'd like to see us come out of here today with identification of what are the major issues that staff would work on. So then that we get a bit more focused statements and recommendations and gives them some opportunity to go to the stakeholders and say, okay, we come back with a different set of, here's our proposed rewrite of these rules based on working with the stakeholders.
May I respond, Mr. Chair?
Yes, you may. Overturf.
I think one of the reasons why I think this hearing took longer than anticipated is because of the sheer volume of brand new proposals that we received in verbal testimony in front of us at this hearing, which is incredibly unfair to us as commissioners in our efforts to prepare and enter into a hearing able to make a decision. And so my concern with allowing additional verbal presentations is I'm concerned about getting new proposals the day that we're supposed to deliberate. So I do want to just say that. My second point would be that I think, Mr. Chair, your proposal about having staff maybe grab us by the shoulders a little bit more and walk us through what the specific rules are and the various proposals that are on the table from different parties, I think there's a lot of value to that. I think that in order to do that, staff also needs adequate time to prepare, which means getting those actual final concrete positions from people well in advance of our deliberations.
Go ahead, Director.
Well, I want to just point of clarification for Commissioner Overturf. To me, your original proposal in which we would put forward one more set of draft rules or at least proposed changes to the existing rules kind of does that. I mean, it kind of sets out, you know, all right, staff has heard you, staff has heard the parties, staff will talk to the parties a little bit more about some of these items, and then we're going to put something on the table. And then it's a question of what is the process for response to those by the parties. And you suggested an opportunity for them to provide a written response to those, I think, all of which makes sense to me. We would, we are not going to go from A to Z on these rules. We're going to have, 6 or 5 or 7 items that we would propose changes to at this point, I think.
At least.
And maybe there's a process there. If we do that and the commission thinks we missed something, you could tell us that.
Right.
Like, I'll use 201. I think we're settled on 201. I'm not going to include 201. If you come back to me and say, why didn't you include 201? We'll deal with that. But and by the way, I have no idea what we're going to do on mapping. So,
Mr. Randall.
So I'll just say I agree with the course that Matt, the directional report, just laid out. I think we've sort of pre-deliberated on a number of things such that there is, the staff probably has a sense from the questions and the discussion that's occurred today and yesterday about the direction we might go on some specific things. Some things are going to be harder than others, to be fair. I think maybe we could do both what Commissioner Overture proposed, which is written responses from parties to the revised final draft proposed rules from the staff. And then some short, a short closing statement from the parties with encouragement or maybe direction to group up, as Commissioner Boygan suggested. I think there's a way to do this in a way that doesn't get out of hand again.
and may I tag into that? So a lot of the parties have time remaining, and we could, through a subsequent pre-hearing order, modify how that, plays out. But I think to Commissioner Randall's point, if I'm just throwing out a number, 27 seconds for closing or a little more, that would be their opportunity to say, staff completely got it wrong, you can't do this, or, something like that.
May I, I am amenable to that insofar as I get an air horn, and if there's any new proposal, I'm allowed to honk it.
I agree with you. I agree.
Is that allowed?
I'm sorry, Commissioner Overture, if I didn't quite hear.
If there's a new proposal in closing statements, I get to honk. Is that allowed?
Absolutely, because I think we're going to say that there will be no new proposals. So, which leads me to the same thing, and I feel a lot more comfortable at least having us have, I hate to say a list, but sort of what do we see as the major issues that are still unresolved with respect to the wording? As an example, the easement. What do we do about the easement language? Is that to be addressed? And our expectation is we would ask staff to go back to those stakeholders and come up with a resolution around easement. So I'd feel better if at least we could take a little bit of time today and identify those things. If not, I'll certainly, I'm only one commissioner out of, I guess, 8 or 7 that are attending today. So Commissioner Overture, go ahead.
I think each of us as individual commissioners can certainly follow up with staff and say, boy, these 4 rules really seem to me like head scratchers, and it would be great if you could spend some more time thinking about them. I think asking staff to say, rule XO4J, go forward and come up with a consensus proposal and bring it back to us so that everybody has agreement. I think if that were possible, we would have seen a lot more consensus and agreement already here today. There may be some issues where the parties' positions are simply irresolvable, and that's where we need to make a final decision with the insight and expertise of our experienced staff. But requiring staff to go back and come up with a consensus proposal, I think, may be asking for the moon.
That was not the intent.
Okay.
So if that was what was heard, I apologize. It was more for us to have an understanding of what are those issues that we see as outstanding and difficult to resolve, and whether that's done in a discussion today, or do we individually, are tasked as individuals to submit our list to the staff, and then they can consolidate that, and it comes back and says, okay, here are the 5 that we have heard from all of you as commissioners, that 5 or 6 that we see as needing further resolution and further work and addressed as a revised set of rules.
Following up on that, it seems to me you and Commissioner Overturf are saying slightly different things. I think you're focused on the commissioners themselves wanting to make sure that the concerns that they've heard or have are addressed in whatever this proposal is, and it may not be exactly the same as what staff comes up with your 5, 6, or 7 changes, which you will presumably develop in discussions with stakeholder group and your own notes. So the question is, to what extent do the commissioners want input into that process, or are we willing to basically just trust the fact that you've heard everybody and you'll take that all into account and come in with your proposal, so that when we are presented with it, it's either what you've done or I guess what a specific party proposes in response, and is that our only choice, or can we as commissioners do whatever we want? If we can do whatever we want, I'm good to go with that.
Can you explain what that means? Do whatever we want.
It's a term of art that has many different meanings.
I think we've had a number of those today.
Remaining minutes, right on task. Well,
So what I heard,
what to do is do it.
you'd like to,
No, it'll take 2 months. We won't be able to come up with a single list. Even in a half hour, an hour.
I don't think we can come up with a single list, but can we come up with, say, 2 or 3 that we really see a need for stakeholders to and the staff to work on?
Can we not just do that in separate lists?
I think
Like the staff is fairly thin?
so long as, this is Commissioner Overturf, so long as we are, as individual commissioners, speaking directly with staff, I think we can convey our own individual concerns and areas of heartburn to them, so long as we are not copying other commissioners on those communications. That's an entirely appropriate thing for us to do, to give that feedback to staff. And then if there's one person who really cares about one particular rule and nobody else cares about it, that it's probably not going to get addressed in the staff's proposal, I would assume. But then you're kind of left to tabulate what it is we're telling you, and so I should ask if that's actually okay with you.
Can I ask a question? Can staff generate that list initially and then distribute it to the commissioners and let the commissioners comment one more time and say, why didn't my concern A get addressed?
Yes.
It's just a list before you revise the rules.
So
Yes.
for clarification, do we send in comments first, then they compile a list and send it out and said, here's what we're going to work on? Okay. Director?
My ask would be that all of your comments each individually fit on a 3x5 postcard, and that you get them to us by Thursday.
Okay. I think,
Because otherwise we just do what I said at the start, which is we send out the list. If you don't like our list, you can then comment on it. I mean, we can send out the revised draft.
I do think
I'm
it'd be-
happy to, you guys send us what.
I think it'd be more expeditious if we provided that. Commissioner Randall?
I agree with that. Again, if there are areas that commissioners would like to see addressed in a new draft of the rules, I think we can let the staff know that individually. I'm comfortable with that personally. I don't think I need to see a list come back from them and see if my issues are on it or not. If possible, I'd like to minimize the exchanges of paper or whatever on this, just to move it along. Again, I think what's most important is to get some language on paper that we can read, respond to, think about, and the parties can read and respond to.
I know that doesn't, I'm not going to make all the commissioners happy with that, but it sounds like I'm hearing generally the majority, that's the direction that we're going to take on that. And I'm not sure that I've got clarification on if we do that, then what form will the closing statements take?
It's up to you.
I have a question. If closing statements are written, would we be able to ask questions at the beginning of the next hearing?
I think when I was envisioning doing written closing statements, they would be just written, and there would not be an opportunity for further question. But there was also the proposal to allow some brief oral presentations at the beginning of the deliberation meeting.
And I think that was your request, Commissioner Hawkins, that there would be an opportunity to hear an oral.
Well,
Yeah, I'm sort of mindful that we established some times for these folks, and they said they wanted additional time, that we keep a record of that, and those folks have that time made available to them when we reconvene.
Just to restate what Hearing Officer Prine pointed out, parties had some rebuttal time that they reserved that they didn't get an opportunity to utilize. And so I think they at least deserve that, if not maybe some expanded, consolidated opportunity to respond to whatever the new draft is. But I wouldn't make a half a day out of it. But
I don't. Total time left is
An hour, 46 minutes.
Which is a half a day, by the way.
That's a morning.
That's assuming.
That's a half a day.
well.
That's assuming each party actually takes their allotted time that they have left. And some parties, I don't know if they even reserve time to come back. Some of them did not. So
Yeah. So we don't know, but certainly encourage people, they want to consolidate and do consolidated. So,
We
but
can find
it's, so
out.
if it's a time, but it's time for rebuttal, because the closing statements are separate from that? Or is that part of that?
no, it was all.
May I propose another alternative? I think that if we are giving parties an opportunity to provide their closing statement, I don't think there's any legal requirement that we allow them the opportunity to do that orally. I think providing an opportunity for written closing statements is entirely consistent with the due process requirements of the Administrative Procedures Act. I think if there are commissioners who find a lot of value in having that oral back and forth with parties, perhaps another option would be to require written closing statements filed concurrent with the next draft of the rules, response comments, and then simply an availability for commissioner questions at the beginning of the deliberation session, where there's not a set presentation time, but rather each party that has provided comments in that second round knows they have to make their witnesses available. And if the commissioners have questions, they'll have an opportunity to ask them at that point. How does that feel?
I was sort of leaning, I thought that's what you proposed originally, more or less, was that the closing statements would be written.
Yeah,
And
this
then-
just has an opportunity for
And then it
questions.
provides an opportunity for Q&A, not in the time, it wouldn't exceed the total time of that hour and 45 minutes or something like that, to where we can just ask questions, we can just ask questions about, because by that time we would have another red line of the rules and the closing statements. And then we could say, okay, here's your closing statement. Based on what we saw from the closing statement and what we see in the rules, we presume you still have an issue with this specific section. That seems, it's not the most efficient way to do it, but
I'm fine with that. To me, it's not a due process issue so much as giving us and the parties the opportunity to fully vet the issues, and I think there's value in that verbal interplay, but I agree that we can manage it and limit it.
Commissioner Randall, yes.
Clarifying question, that's whether we want closing arguments from counsel or we want witness testimony or to have witnesses available. I just want to note that, there is expense to the parties to bringing their witnesses back for another day. And do we anticipate just taking argument on rule language, or do we anticipate receiving party testimony? Is the record closed for new matter, for factual issues, or is it
We
really just attorney argument?
small comment, but then you make it clear. I don't believe we would close the record. I
Okay,
think
that's right.
it would be up to the option of the people coming back to bring their witnesses. I think what we could say is if it's all right with the commissioners, if we're not going to make that a requirement that they bring them back, that our expectation is between working with staff and the stakeholders, the written closing statements, the verbal Q&A, that would satisfy us as the commissioners of everything we need. I mean, we had very fulsome discussions today and testimony from all the various witnesses.
I
don't think
personally
need-
agree. I just heard reference to witness testimony as part of the closing, and I wanted to, again, just provide some predictability for the parties. So I'm good with that.
Are you happy with that?
Yeah.
Okay. Commissioner Jolly, you're okay with that? Okay. All right. What else?
Are we talking about doing this during the mill levy hearings that we set aside? Is that what we are?
That's my
discussing?
understanding, is it so that we can accommodate Commissioner Overturf being present? Yes. Okay. All right. That we would do it is it the 12th and 13th of February? But I think that notionally we were going to do the mill levy rulemaking first and then move to this.
Yes.
So would you, just to make it clear for all the parties, do rulemaking and mill levy on the 12th, and if there's any spillover on the 13th, but we'd only readdress this issue on the 13th. Or
A little guidance. I mean, how long do we expect the mill levy rulemaking to take?
2 days.
It seems a fairly, thanks, fairly cut and dried.
I think it will.
it's a lot fewer words.
It's better not.
I'm kind of serious. I mean, I'm not being facetious. I think it will.
I would say that we do that well, what we could do to provide some stability is that we do the mill levy on the 12th and finalize this on the 13th. So maybe a short day on the 12th and a very long day on the 13th. So Commissioner Overturf? Okay.
I don't know what's the right way to do it. I'm just trying to.
There is no right way, unfortunately.
If the mill levy did take all day long and everybody came for this, you know, to hear it on the first day and we never got to it, then they're just all sitting out there.
I guess perhaps it's 2 very long days. So that we'll commit that we will finish on the 12th with the mill levy so we can take this up on the 13th. Yes.
Mr. Chair, just to qualify, we landed on commissioners will submit lists of their major issues by Thursday.
Yes.
Close of business Thursday.
Yes.
And you can send those to me and I will distribute to everyone.
And again, only to Ms. Prine, no copies to other commissioners.
And then we will provide you back with a timetable of how we see all of this.
Here's what we see the priorities are, and then we have the option, but not the obligation to comment on that when it comes out. But those comments need to be immediate. So if it's something that says, well, what happened to my piece, then you can reply to that, but there's not a requirement to do that.
So when you say work with staff, that means sending them to Julie or calling Stewart?
We send everything, our issues, we send it, so, one window approach. So we send our comments to Ms. Prine, it gets staff consolidates, and then it come back and said, these are the items that we see we need to work with the stakeholders on. The outcome of that being another revision to the rules. And then written closing statements. I don't necessarily see that has to be concurrent with the rules being sent to us, but that should be in plenty of time prior to the 13th for us to be able to read them and collect our questions and so on. So Director Lepore, I know, or Commissioner Overturf.
Yeah, I think there is a lot of value in having the closing statements be concurrent with the new rules, because I think we want to make sure that the concurring statements are addressing what has happened to that date. And then we want to make sure that the responsive comments are really only responding to the new red lines that staff has put out. You made a new definition of supercritical isolation valve, and I have a problem with that definition. I think that's important for us to be able to kind of funnel all of this into orderly deliberations in February.
Okay. All right. Sorry. Yes, sir.
Yep. So I just want to be sure I'm clear. So written closing statement submitted to us on the same day that we propound the next set of revised rules. That's what I was thinking. Okay.
And then
Subsequent to that, an opportunity for the parties to respond to the revised rules.
yes,
And we can set page limits on the response.
yes,
Can we set page limits on the closing statements?
yes.
Great.
So then that means the stakeholders are they're going to have two documents. They're going to have a set of closing statements and then a set of responses to revised rules, all of which we will have in writing when we start the
We're
rule.
going to have these great binders. We're going to sit down. We're going to just get it done.
And you're going to ask them questions if you, at your discretion, verbally at the next hearing on their responsive statements.
And the closing statement. If you have any questions on either document. I'm assuming that's what you contemplate. All right.
Okay. Think I got it.
Do we need
Could I ask a question?
Yes, Commissioner Randall, because I'm going to ask Mr. Davenport if we need to formally make a motion for all of this, or if we can just where we go.
It
So
seems
I'm
to
gonna
me
need some legal
I might
answers.
benefit from having party responses to the final draft proposed rules that the staff is going to prepare in response to our direction to address certain subjects. So the timing that Commissioner Overturf laid out, wherein staff issues a new red line of just changes to the December 22nd version, and we get the parties' closing statements that will not have seen that language, seems a little out of tune to me. Just a bit. And so I wanted to, and I'm sorry to upset things. I know there was sort of general head nodding in that direction, but wanted to just see if anyone else thought that it might be nice to have the parties responding to the final rules that the commission will have in front of us to consider. And again, we can make changes and all that, but I would like, if we're going to consider those, have the parties have the benefit of the parties' view of those changes.
And I agree, and I was starting to struggle with that as well, that they may choose to change their closing statement, because it may be that they're going to write a closing statement that says, and based on closing it, based on what they know today with respect to, say, mapping, for example, or isolation valves, and then that gets resolved as part of that work with the stakeholders. So now they don't have to talk to it anymore. So the closing statement and the response may be somewhat different. So that was sort of, and I did a poor job of elocuting that or speaking that, that's why I would like to see the revised rules come out, then a response coupled with a closing statement.
Yeah.
That's fine with me.
Okay.
It makes more sense to have that after they've looked at any changes the staff's recommended.
Yep.
All right. So thank you, Commissioner Randall, for being much more eloquent in that.
Well, so now I think we probably just need a fifth pre-hearing order, or whatever it's going to be called,
Yeah.
to lay out some of these deadlines, but I hope the direction's
Okay.
somewhat clear.
Mr. Davenport, does this need to be in the form of a motion since this is a rulemaking hearing?
Yes. At a minimum, we need, not the whole thing. At a minimum, we need an approved motion to continue this rulemaking hearing until February 13th. Isn't that That's the date we set. Consistent with the direction that you've already given staff for that final pre-hearing order, but we do need a formal motion seconded to continue this rulemaking hearing till February 13th.
All right.
So moved.
A motion has been made and seconded. Would someone like to clarify what the motion was, other than it will continue the hearing to February 13th, at which time we will have received another set of rewritten rules per the direction that we've given staff, and proceed with our deliberations? Or just to continuance? I mean,
I think all that's required is to continue the hearing.
okay, then we'll just say continue to February 13th. All right. All in favor?
Aye.
Opposed, same sign. Thank you. Thanks for the direction. At this time, we are finished until the 13th.
Yeah.